Well, let me welcome all of you. As Kristen pointed out, this is our 19th annual Educational Law and Social Justice Forum. We started these forums in 1999, and we wanted to establish a platform for the university and the community to discuss some of the contemporary issues in education, especially those issues that deal with tensions and controversies that arise from a democratic, pluralistic society. This morning, I was looking over some of our earlier forums, and I realized that one of our very early forums was on Columbine. And Columbine had just occurred around the time we started the forums. And at that time, we thought that this would be an aberration. And we never realized that it was going to be a continuing tragedy in our country. And so we're continuing our discussions on these issues, both through the forum and through our journal. If some of you are not familiar, we are also publishing a journal of educational controversy. It's been around since 2006, and it helps you to continue to look more deeply at some of these issues. As a matter of fact, you all have a questionnaire that we filled out to get some feedback from you. I'm particularly interested in the last question. I would like to know what your thoughts are. We'd like to hold a series of these seminars and workshops next year to talk about some of the topics that were raised in the journal. So, we'll take maybe 2 articles and come together in a seminar, and you have a chance to not only read them, but to talk with your classmates and your colleagues more deeply about these issues. So if that's something you think you might be interested in, please do indicate that on your questionnaire, okay? Of course, one of the topics in the news today has been the protests that the young people are engaged in, protesting against gun violence in the society. And I picked up the Washington Post this morning, and I came across this quotation. I wanted to share it with you. I need to be able to see it, though. They said that in March, the student walkouts protesting gun violence involved the largest number of recorded locations in a single-day protest in United States history. It's quite something that these young people were able to pull off. Well, we thought we should discuss these issues a little bit more deeply with you. I noticed that some of the schools have supported students. Other schools have actually punished students. I read that one school district actually used corporal punishment to punish their students. We don't have that in Washington State. But I thought we ought to have a forum where we can inform you about the law governing all of these incidences related to the protests that we're seeing. And so today we're very fortunate to have a speaker who brings a special expertise to us and who will talk about these issues. We'll also have a Q&A at the end where you can ask any question you want to ask. And by the way, we are videotaping it, so if you don't want to show up on the videotape, just keep that in mind. By the way, on your program, I listed a couple of articles that we have published in the past that relate to these topics. And I don't know if you're like me, but whenever I come to a lecture, I like to go home and I like to read up on these issues. So in order to give you an opportunity to inform your thinking further, we have a couple of articles that are directly or indirectly related to these topics. Some of them directly are related to speech issues. Others, for example, we have a issue devoted entirely to the school-to-prison pipeline. We have another issue, our current issue deals with Black Lives Matter and the education industrial complex. So it covers a wide range of things, and we invite you to come to the journal and take a look at it and keep informed about these issues. Well, let me introduce our speaker, and I'm going to need my glasses for this one.
Could also cut that in half.
I did research on this, you know. Vanessa Hernandez is the Youth Policy Director for the ACLU of Washington State. She is a graduate of the University of Washington School of Law, where she was the Gates Public Service Law Scholar. Prior to her law school experience, Vanessa taught middle school history and drama, and she's also the parent of 2 children in the Seattle Public Schools. In 2016, the League of Education Voters recognized her for all of the work she has been doing toward improving public education across Washington State. As a teacher, they wrote about Vanessa that her classes focused on empowering students with knowledge, developing their skills to understanding bias, evaluating information, and advocating for what they believe is right. As an attorney, they write, she sees the power of the law to contribute to social movements. She is particularly concerned about the phenomena of the school-to-prison pipeline, something, as I mentioned, our journal has extensively written about. This is a quotation from Vanessa that we have on your program. She writes, "My job is to fight to keep young people in schools and out of prisons and jails. I work with policymakers and community members to replace punishment-based approaches with positive, preventive, and restorative approaches that can eliminate pipelines to mass incarceration." I think Vanessa brings a very unique perspective to us. She brings not only her understanding of the law around these issues, but she also brings us her understanding of the realities of teaching in the public schools today. And so please join me in welcoming our speaker for tonight, Vanessa Hernandez.
I'm really excited to see so many people here to learn about speech and protest in public schools. And I'm guessing that a fair number of you are in training or considering or planning to be educators yourselves. Is that loosely right? Sort of nod of heads? Okay, so perfect, because I get to seed in you all of the things that I hope schools do so that I never have to take another one of those phone calls where I'm like, oh, really? What I'm going to talk with you about today is really what the law currently says about the operation of the First Amendment in schools. And Washington has its own analog to the First Amendment, and in some areas, state and federal law are radically different. Don't get me started on privacy, where Washington law is so much better. But for the First Amendment and speech and protest, it's pretty much the same. So I'll be talking about a lot of federal cases in addition to Washington State. And I'm going to talk separately about the rights of students and the rights of teachers, because they are radically different levels of protection. I also, though, want to acknowledge that what the law says is, one, surprisingly, not always crystal clear. So there is a lot of gradation and a lot of sort of fact-specific analysis here. So I may be telling you things where it's like, this is likely what would happen, but it is all, to some degree, there is some fuzziness depending on where you are, what the facts are, what court you're before, who you are. And I also want to acknowledge that there is often an unfortunately wide gap between what the law says and what people actually do. So, my saying this thing is illegal is in no way, shape, or form minimizing the fact that things that are illegal happen often within our systems of government. And then the last thing I will say is that I think there is a robust debate in this country now about the role of the First Amendment and about perceived tensions between the First Amendment and racial justice. The ACLU, to some degree, is having those discussions. I have my own personal feelings about those discussions. And so again, saying what the law says or does on this is in no way, shape, or form minimizing that debate. The law is an evolving thing, right? It is not a static, like this is the way it is and this is the way it always should be. So I encourage folks to kind of keep that in the back of your mind as we go through this. So we can go on to the first slide. The students have a fair amount of protection to speak their minds in public schools, regardless of whether the adults who are teaching them or the adults who serve as principals or school administrators may disagree with their viewpoints. So the kind of fundamental case on this is called Tinker versus Des Moines. It was an ACLU case involving 13-year-old Mary Beth Tinker, who wanted to protest the Vietnam War by wearing a black armband over her school clothes that had a peace sign on it. That she just wanted to wear an armband. And when the school administrators got wind of this, they convened a special school board meeting so that they could pass a regulation that said that any student who wore a black armband to school would immediately be suspended for the rest of the school year. Which, let's all pause on that for a second. That is some serious adult control activity. But that is what they did. And so Mary Beth Tinker, along with another student who wanted to engage in the protest, called the ACLU, and they sued the school district. The case went all the way up to the U.S. Supreme Court. And what the court held there was the sort of famous line that now everybody trots out, which is that students do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. Which means, yes, you may be a minor, yes, you may be in school, but the First Amendment still applies to you. And believe it or not, even still today, I have school administrators who say, but they're 12. And it's like, and they still are protected by the First Amendment. Children are allowed to have opinions as well as adults. And so what Tinker held is that the speech that was at issue here was sort of core political speech, right? It was expressing a viewpoint about an important, controversial political topic of the day, and that the particular form that this speech was taking, which is wearing a black armband, was in no way, shape, or form disruptive to the school environment. Other people might not like it. Other kids might disagree with it. Teachers might, think that it was affronting to them in some way, shape, or form. But the simple, wearing of a black armband is not disruptive to the school environment, and the school can't prohibit it just as it stands. And from Tinker has evolved a sort of baseline principle that students have First Amendment rights in schools. But next slide. There are limits to that, right? The way that Supreme Court case law almost always works is there's a big grand principle and then they sort of start chipping away at it in little areas. So the big limits for speech in public schools are this. Student speech is not protected if it is defamatory, and we'll get to what that means in a second. It is not protected if it is obscene or lewd or profane in any way. And it is not protected if it is actually disruptive of class time or school operations. So we'll go through each of those examples in some details, and I'll share sort of actual cases where these things played out. So next slide, defamatory. Defamation is a term under the law that basically means if you say something about a private citizen that is false, that you know or should have known is false, and that causes significant damage to that person, to their reputation, to their interests, you can be held liable, through a lawsuit in civil court for that statement. And And that applies to students as well. So if, for example, you as a student publish something in a school newspaper that is totally false, that you know is false, that is about a private citizen and that causes that person harm, if you accuse someone of having committed a crime without bothering to investigate it and publish that in a school newspaper, you can actually be held liable for that. That person can sue you for damage to their reputation. This most recently came up in Washington State in the case of a high school newspaper in Seattle, actually like in my neighborhood, like 4 blocks from my house. So to set the stage, my neighborhood is lovely, but there's like one particular block of my neighborhood that is pretty much like just all completely run down houses with like broken windows and weeds growing all over the place that haven't been painted since like 1922 and like falling in roofs and things like that, right? It's a different from the character of the rest of the neighborhood. And the high school is right across the street. So the high school newspaper wrote an article about those houses in which they described those buildings as, they called it Sisley slums. Sisley is the name of the landlord. And they said things in the article like the owner of the houses was a reputed slumlord who had been accused of racist renting practices, and the landlord sued the high school newspaper for defamation. This case went up through the Washington Court of Appeals, and the Court of Appeals held that that wasn't defamation, in part because Mr. Sisley couldn't prove those statements were false, because the students were able to cite to reports calling him a slumlord. Like the Seattle Times had published an article calling him a slumlord, and they were also able to cite to other articles that accused him of racist renting practices. And saying that someone has been accused of something or reported, if they in fact have been accused and it has been reported, is not false, right? So, this most often comes up again in the context of high school newspapers because defamation is triggered by a publication. It's not just like you talking to your friend. You have to actually like put something out in the public sphere. But again, unless a statement is defamatory, even if it might be untrue, students can't be held liable or can't be prohibited from making those statements in school. Next slide. Obscenity. So the obscenity standard comes from this case also out of Washington State called the Bethel School District case. And it was a school assembly where a student was nominating his friend for class president, and he gave this nominating speech that was like a really unsubtle double entendre, where he described his friend as firm in his principles and firm in his pants, and he'll take his point and pound it into the wall, right? Just really, like, boys. And the school district expelled him for giving that speech at assembly, and he sued the school district, and the U.S. Supreme Court held that in fact in that context the student's speech wasn't protected because within the educational environment the school has an interest in maintaining a healthy and safe educational environment, and prohibiting students from giving highly sexualized speeches at assemblies is within the school's legitimate duties. Now, a couple of things I want to note about that. In order to qualify for lewd or profane and unprotected in this sense, something has to be obviously lewd and profane, considered in the entire context, right? So that Bethel School District nomination speech was pretty obviously profane. It wasn't exactly subtle what the kid was doing, right? This most recently came up in Pennsylvania in a case where some middle school students, in the context of Breast Cancer Awareness Month, one of whom had a family member who had been diagnosed with breast cancer, so actually cared about breast cancer awareness, wanted to wear bracelets that said, "I heart boobies." And so they passed out bracelets. This was part of a national breast cancer awareness campaign. They passed out bracelets in their middle school that said, "I heart boobies." And a bunch of people at the school got very, very upset because they're talking about boobies. And apparently, like, some other kids said things to them about boobies, and everyone got very uncomfortable. And so they told the girls to remove the bracelets. The girls refused to move the bracelets. They got suspended. Are you all noticing a trend here? They went to the ACLU, they filed a lawsuit, the case went to the Third Circuit Court of Appeals over on the East Coast, and again the Court of Appeals held that in this particular context, the use of the term boobies is not lewd or profane, right? The whole context of this is that it is an educational campaign that is where the statement "I heart boobies" is nationally recognized to indicate breast cancer awareness. It's being done by these students within that context, and so unless it is clearly and obvious that what the students are saying is lewd or obscene, the school cannot ban that kind of speech. Next slide. You know, the defamation and obscenity sort of categories for prohibiting student speech are less frequently used than the disruption category. So what Tinker held is that a school can prohibit speech that it has a reasonable basis to believe will be actually disruptive of the educational operations of the school. So I'm going to highlight 3 types of situations where this comes up, one of which is highly, I think, contentious in this country. So the first is student dress codes. Schools are allowed to have dress codes, right? But oftentimes dress codes get applied to students in a manner that is determined by stereotypes about gender. And so where this has started coming up more recently is students who, for example, may identify as female or be identified by the school as female, but who want to wear a tuxedo to a prom. Or a male student who may be identified by the school as male, but who may decide to wear a dress to the prom. And what the courts have pretty uniformly held is that dress codes that are based purely on stereotypes about gender violate the First Amendment. Because what you wear, right, is an expression. It is speech, right? It is an expression of yourself. And if you are wearing a particular article of clothing to send a particular message, unless that message is actually disruptive to the normal operations of the school, query what would be actually disruptive at prom, right? It can't be prohibited by the school. This also comes up often in the context of students who want to wear t-shirts that express political messages. So unless the school has a sort of like no t-shirts with writing on them policy, they generally are not allowed to prohibit t-shirts that have political messages because, again, just wearing a t-shirt in and of itself is not disruptive. This came up a few years ago in Oregon where a student wanted to wear a shirt that said "Jesus is not a homophobe." Some people at that school got very upset. In fact, in that school, a whole bunch of students threatened to boycott school because someone was wearing a "Jesus is not a homophobe" shirt. And the school said, well, the fact that those kids are boycotting, that's a good enough reason. It's disrupted because we want kids in school. And what the courts held is the fact that other students may take independent action isn't, again, enough to find a disruption, right? If you want other students to come to school, then you should enforce your attendance policy. You shouldn't discriminate against or silence the student who is wearing a t-shirt because, again, the t-shirt itself is not a problem. Where this gets dicier is in the context of symbols that carry more weighted meaning, like the Confederate flag. There are Confederate flag cases all over this country, and they do not consistently come out on the same side. So a couple of things, right? The first is that I believe, and I think that history is absolutely unequivocal, that the Confederate flag is a symbol of maintaining slavery and oppression against people of color, right? Like that is what the Confederacy was founded on. And you know, folks who think it is just about heritage maybe haven't stared the totality of that heritage in the face. On the other hand, and the Confederate flag has also been used throughout history as a symbol of targeting people of color specifically, right? If someone plants a Confederate flag in your lawn, you know what that means. On the other hand, courts have held that the use of the flag in and of itself is not disruptive. There have been school districts where the Confederate flag, where there have been school districts that have legitimately banned the Confederate flag. But in order to show a disruption, what has typically had to happen there is that the schools have had to show some evidence within their school community of historical racial tension, or some evidence within their school community of the flag being used as an instrument of race-based bullying, harassment, intimidation. So it has not typically been enough to say, look, in this country, the Confederate's flag has been a symbol of the oppression of people of color. But schools that can say, in this particular community, the Confederate flag has been used as a symbol of oppression of people of color, have been allowed to uphold those bans. And so it really does often come down to the facts of what's going on in that particular school. And I think more specifically, the care that the school has used in sort of fashioning the limits, right? Next slide. The other area where this has come up all the time is in protests around the national anthem or the Pledge of Allegiance. This is one of those ones where I just go, oh God, really? Whenever I get a call about this, because I think like I said, the law is not clear. This is one of the ones where the law is just like straight up clear. There's just no legitimate debate to be had about this. It is totally 100% absolutely legal for students to kneel or sit or remain silent during the Pledge of Allegiance or the national anthem. The Supreme Court has said that the government cannot compel these displays of patriotism. It is also illegal for schools to threaten or publicly shame students for this. There are cases on that. It is also illegal for schools to require students to notify their parents and get a permission slip, which happened recently, when they are sitting or kneeling or refusing to stand for the Pledge of Allegiance. And again, that I think is an area where the law is absolutely, completely, and totally clear. And again, the simple act of kneeling is not itself disruptive. And that is a picture of the Garfield High School football team, who all kneels during the national anthem. Next slide. So, bong hits for Jesus. So this is a case that honestly it's a little odd. And I highlight it because I personally think that this case is sort of a one-off, that it doesn't really establish much of a principle, but worth flagging anyhow. So this is a case from 2007 out of Alaska. Again, another ACLU case where the Olympic torch parade happened to pass right by this high school. And the high school let all of the kids out of class to go watch the Olympic torch like run through their town. And then right as the torch runs past, a bunch of kids unfurl this gigantic banner that says "Bong hits for Jesus," and they all get suspended. And to this day, I don't think anyone, including the young man who made the banner, really can clearly articulate why it said "Bong hits for Jesus." Like, I mean, the best explanation was it was something funny and I wanted to get on TV. And I think that's probably what there was, right? But it wasn't like a deep political sentiment about like Jesus and like marijuana. But the school was really pretty upset about it because it did get on TV and it was something that sort of, got a lot of giggles and they didn't like it. And so they suspended it, went up to the US Supreme Court. And the Supreme Court in this really, they didn't find that this was disruptive to school operations because it wasn't really. And it's obviously not profane or lewd. It doesn't fall into any of the sort of categories of exemption. And so basically what they said is, well, schools really do care about keeping kids off drugs, and the school could interpret this as advocating illegal drug use during a school event, and so we can prohibit it. It's hard to see outside of this case like how that principle gets applied much of anywhere else. But I flag it for you because it is out there, right? This idea that student speech that promotes illegal drug use during school activities may somehow be different, even if it's not disruptive or lewd or defamatory or profane or any of the other kind of ordinary categories. Next slide. So walkouts and protests are the other area where this has been coming up a lot. The National Student Day of walkouts to protest gun violence was probably one of the busiest times around these questions that I have ever seen. So the general rule is this: students are free to organize protests during school hours so long as they do not interfere with the ordinary operations of the school. So you can't, for example, without consequence, stage a protest in the middle of the hallway where you're banging on the doors and, you know, like disrupting the teacher's ability to teach their lesson, right? But you can, for example, have a protest during the lunch hour. The national walkouts were challenging, though, because of course those weren't, they weren't sort of during the, you know, on essentially the school's timeline, right? Everybody walked out at a very particular time, but it was also a very contained, limited, like 17 minutes, right? It wasn't that the students were completely disrupting the entire school day. It was literally just a very tight, contained window of time. So the general rule on this is that, and this is Washington specific, students can receive school-based consequences for walking out of class in protest. But those consequences have to be consistent with the ordinary consequence you would get for walking out of class, right? So they have to be not based on the viewpoint or the subject matter of the protest, which means they have that everybody who engages in that activity, regardless of why they walk out, gets the same consequence. And those consequences can't include suspension, because it's not legal in Washington state to suspend a student for a first-time instance of absenteeism or tardiness. So to reiterate, the consequences have to be the same that you would give to everybody else who walks out of class. And this is the area where schools in Washington struggled the most. Because initially, some schools were like, we're only going to let the students do a walkout if they have a parent's note in advance, and otherwise it's, 10 days of detention. And it's like, well, what's your ordinary policy if a kid just doesn't go to class, right? Like, what if they just go hang in the bathroom for 17 minutes? It's like, oh, well, in that case, they get a robocall home because they were tardy. And it's like, well, if a kid who cuts class to hang in the bathroom gets a robocall home because they were tardy, you can't do 10 days of lunch detention for the kids who are walking out for protest, right? That is a consequence that you are tailoring specifically based on the expressive activity that these kids are engaged in, and it's not okay. Because your only interest here is to get kids to class, right? It is not to opine about your feelings about whether kids should be walking out or not. And then again, the consequences for this particular kind of protest have to be applied equally, which means that if you are a school that has sort of dueling protests, and again, there was some inconsistency here in Washington that got cleaned up, but initial inconsistency. If you have, for example, a pro-Second Amendment rally and an anti-Second Amendment rally, you have to give all of those kids the same consequence. You can't give the pro kids something different than the anti-kids. Next slide. The other area where this came up pretty frequently is off-campus speech. So this is an ACLU case, again, out of Nevada, out of the National Day of Walkouts. So a student walked out, and he decided to use that time to call his congressman, which, like, good on you, democracy in action, right? And his congressman was maybe a little more frustrating, his congressman's aide, than he would have hoped. And so he told his congressman's aide that he thought that his congressman should get off his fucking ass and do something about gun control. Maybe not the words I would have used. I do not ever advise yelling at congressional aides, because Lord, do they have the hardest job on earth. But, again, not disruptive of the school environment during a time where he walked out. And the congressman's office called his school, functionally to tattletale, right? And said, did you know that one of your students called and used profanity? And then the school suspended him. And the ACLU representing the family argued absolutely correctly that this was off-campus speech, and the school has no interest in what you do or say off-campus, right? If off-campus, for example, in school, and I'm going to use, my words because y'all are in college and thus adults. If in a K-12 classroom, right, if one of my students, when I had been teaching 7th grade, wanted to call me a fucking bitch, and maybe one of them did, right, like, I could, as a teacher, exercise my prerogative to discipline that student, right? But if he wanted to go home and tell his mom that I was a fucking bitch, it's fine. I don't have any say in that, right? It is not my job as an educator to police what my children do or what those students do in their off time. And so the ACLU, essentially threatened to sue the school district. The school district agreed to remove the suspension from the student's record because, again, it had no First Amendment right to police his tone. They might not have liked his tone. They might have wanted to educate him more effectively on better ways to persuade your congressman, but they don't have the ability to penalize or punish him or deprive him of his constitutional right to an education because of that. Next slide. The threats are now in the sort of post-Columbine, post-Parkland, post-Santa Fe, post all of those things, right? Areas where, honestly, I see a lot of risk. So these are those lovely clear backpacks. Have you all heard about this? So, and this is happening all across the country. It's also happening in Washington, where students are now required as a safety measure to carry clear backpacks. No actual backpacks allowed in school. And the clear backpacks are just a symbol of a real fear among students, among parents, among educators about the threat of school violence. So a couple of things I will say about that just as background, right, which is that even though it doesn't feel like it, school violence is still incredibly, incredibly, incredibly rare. That said, kids do and say things all the time that can get perceived as threatening, as strange, as weird, as indicating some potential of risk for violence. And sometimes those threats are legitimate, but most of the time, those statements don't actually indicate a threat, right? They just indicate like a kid who is having something else going on in their life. So one example is if a student turns, and actually the people who do this the most empirically are 10-year-olds. If a 10-year-old turns to another kid and makes a gun motion and says, "I'm going to kill you, I wish you were dead," what is the school to do about that? Right? Or if a student posts on social media, "I wish this place would burn to the ground," what is a school to do about that? Right? And saying "I wish you were dead," right, in most instances is just an expression of frustration from a kid who doesn't know what else to do with their frustration. Like, again, the biggest peaks in these kinds of threatening statements are in like 4th, 5th, 6th grade. It's really littles who do the bulk of this. So, as a general matter, to be a real threat, a true threat unprotected by the First Amendment, a person has to make a statement that a reasonable person in their shoes, and in accounting for reasonable person, you have to account for age and maturity, would believe, or that a reasonable person would know that the person hearing that statement would interpret it as a sincere expression of an intent to cause harm. Okay, so that's super lawyery, multiple steps. But again, in order for something to be wholly unprotected by the First Amendment and a true threat, you have to prove, essentially, that 10-year-old who said to his friend, "I'm going to kill you, I wish you were dead," that 10-year-old knew that his friend would think that he was actually intending to kill him. Doesn't mean the kid has to actually have the intent. It just means the person hearing it would have to believe that, and you'd have to know, right, that was reasonable. But what I see most of the time instead happening these days is that schools are starting to implement a sort of zero tolerance approach to any statements that kids make that are, again, threatening, challenging, and I say threat in the broadest sense of things, right? Because sometimes it's not even an explicit, sometimes it's just, I hate everything, I wish I was dead, and then the kid gets expelled. Or I'm so angry I don't even know what to do with myself, and then the kid gets expelled. Or the kid writes a poem or some angry rap lyrics and they get expelled. And oftentimes it's not directed at an individual either. So I see a lot of zero tolerance happening here, and I think that is a mistake, right? I do not think that every statement a kid makes that is troubling, that is odd, that is untoward, causes an actual disruption to the school environment, right? I don't think two kids scuffling on the playground and one of them says to you, I wish you were dead, is actually disruptive to the ordinary operations of schools, right? Schools are places where people have emotional conflict and where they bring their sort of whole social emotional selves, and where schools, work within that context. But I also think it's a mistake because kids are safer at school, right? And kids who are out of school because of things that they have said are much more likely to have access to weapons, to have access to drugs, to have a lot of time to stew and feel upset. And that may not serve the ultimate safety goals that we have, right? I think that schools would be much better positioned instead of having sort of zero tolerancy approaches to threats, right? One, better position from a First Amendment standpoint, but also just better position from like we all care about this being a safe place. If everyone sort of stopped and took a breath and figured out, is this statement really evidencing some intent or ability to harm? Or is this a kid who's got something going on who might need some more productive outlets? So, I think this is an area where the law is going to continuously be evolving, and it's a challenging one right now. So next slide. So then that brings us to teacher speech. Sadly, for all the future teachers in the room, your students are more protected than you are by the First Amendment. The standards for teacher and student speech are pretty radically different. And so I'll go through, and I will also say that the teacher speech law is like all over the map. And so it is challenging to give people kind of hard and fast rules, and instead I'm mostly going to give you examples. So the first thing is, when you are in your classroom, when you are on the clock, when you are putting up your bulletin boards and teaching your lessons and making your handouts, you are not speaking in your personal capacity as an individual human being. You are like a mouthpiece for the government. You are speaking in your official capacity as an educator. And as an educator, the school has the ability to constrain, in a K-12 school, universities are different, but in a K-12 school, they have the ability to constrain what you do and what you say in that official capacity. That means they can prevent you from putting up things on the bulletin board. They can prevent you from assigning supplemental reading material. That means that they can direct how your class should be taught or not taught. And it means that if you deviate from those rules, assuming they exist, and not all schools sort of cabin this, that you could face potential discipline. Obviously, teachers are not and cannot be scripted every moment of the day, right? That is impossible. So I think that as a general rule, it's a really good idea if you are looking for schools to teach in, to get a sense of what are the expectations around curriculum in particular, and do those expectations around curriculum feel like ones that you can live in, right? There are some schools where like the curriculum guidelines say you shall not teach any politically controversial topics. It's like, I would have gotten fired on day one. And instead, I taught in a school where basically, like, I got here are the standards for the year, and I wrote my curriculum, right? And, you know, I showed it to my principal, and they said, cool, but, like, the avoidance of controversy was not a value in the school I taught in, right? And so I think to the extent that you have sort of deep feelings about the subject you are teaching, and I think that goes like super doubly for the liberal artsy type folks amongst us, knowing what you're getting into in advance can save you a world of trouble. And then also, you know, to some degree, keeping some boundaries around your personal viewpoints and your subject matter. The teachers who get in trouble in their official capacity thing comes up most often with people who have these like displays in their classroom, like billboards to whatever the thing they are passionate about that's wholly unrelated to their subject matter. So like biblical, you know, biblical bulletin boards in science class, for example. And again, it is totally great for there to be hyper-religious science teachers, but that bulletin board is an extension of the school, and the fact that you are a deeply religious person can't override that. Next slide. The harder part, though, is when you're not speaking in your official capacity. It's not your class, right? It's not, you're in your off time, you're in your personal time. And schools do still have some authority, and it is a balancing test, to limit what teachers, to discipline teachers based on speech that is not necessarily in their official capacity. And this is from a case called Pickering, where Mr. Pickering was a teacher who was really upset about the way his school board was functioning because they were putting a lot of money into building new athletic fields and not into, like, you know, paying teachers. And so he wrote a very stern letter to the editor, and the school fired him because they said that he was, you know, that he was an employee of the school and they could fire him for whatever reason they wanted. He went up to the Supreme Court, and the Supreme Court said, no, I mean, you can't fire him for any reason, because as a teacher, he does still have First Amendment rights, but his First Amendment rights are sort of, it depends, right? And here's how it depends. So the first question the courts ask is the teacher's speech on a matter of public concern? Does it concern something that is generally of interest to the wider public? Or is it really just sort of intensely personal stuff? So like if you as a teacher want to misogynistically bash your wife, right? That's not really a matter of public concern, like your grievance about the fact that your wife doesn't do your laundry properly, right? And if you went and spent if you just went and spent all of your time around class, like yelling about your wife, that's not a matter of public concern, right? So if your speech is not on a matter of public concern, the school has pretty broad latitude. But if your speech is on a matter of public concern, then the courts move into asking, well, does the speech disrupt the ordinary operations of the school? Is your speech in some way, infusing what's happening in the school environment? And then they sort of balance those against each other and say, well, does the school's interest in preventing that disruption outweigh the teacher's right to speak? And so that almost becomes a sliding scale of like, well, how disruptive really is your speech versus how important is it for you to be able to speak on these matters? So next slide. Again, I'm just going to give you some examples, and maybe we'll do some vote. So I already told you about Mr. Pickering, critical testimony before the school board regarding increased athletic budgets, so we can skip that one. So what about if you as a teacher participate in a protest rally outside of school hours on the weekend? How many of you think that you can be disciplined for that? Okay, just one. I think it'd be hard for a school to discipline you for just participating in a rally outside your normal hours. I think there may be some limited instances where that would be allowed, and I'll talk about those in a second. Okay, what about if you wear a political button, like one supporting a candidate? Vote Trump. How many of you think that you could be disciplined for that? Yep, you are all correct. Schools have general leeway, and courts have upheld limitations on candidates for office kind of speech, right? Like, no teacher shall wear a button endorsing a particular candidate for office during an election season. It's less clear how that applies to issue type buttons. And I would say that that is one where it is super, super fact specific. I think the ACLU's position would be that a button worn by a teacher on a particular issue, unless that button is like specifically targeting of a student or a student's sort of, protected class, that wouldn't be a problem. So like, if you wear an ACLU button, that probably shouldn't get you fired, right? I mean, I don't think the First Amendment would permit that. But there have been cases where teachers have faced discipline because of wearing issue area buttons, most recently in Fresno. And again, my opinion is that this is illegal, but it hasn't gone through the courts yet. A teacher who was fired for wearing a Black Lives Matter button to school. Because the school prohibited any controversial button, and they deemed Black Lives Matter to be controversial. Now, there are a whole bunch of holes in that logic from my perspective. And I also think politically, like from a First Amendment standpoint, just because something is controversial does not make it inherently disruptive, right? Things can, like, if we are to accept anything as a country, it is that we can have civil disagreement with each other, right? And so the second that a school crosses into anything that is remotely controversial that not everybody agrees with, they really are sort of forfeiting the entire purpose of public education, which is to enable an informed citizenry to have like legitimate and principled disagreements. But I warn folks that that hasn't fully played out in the courts, and that some schools will still have policies that say no controversial buttons or t-shirts or whatever. Yes?
What about on like personal properties, aka like a car or like a bike, that's like parked at the school and like the teacher has like the assigned parking spot?
So I have not seen cases like that, but I think, again, from a First Amendment standpoint, the ACLU would argue, and I think we'd win, that bumper stickers or slogans on a teacher's car are not actually disruptive of the school environment, right? Students aren't it is not an ordinary operation of the school that all the kids are parading past your bumper sticker to read it. And because of that, nothing on that really can or should be inherently disruptive. Again, I think it might be different if you had, for example, a button on your car that said something intensely targeting to a particular group who you knew were represented in your school, right? So if you know, because it is correct, that 15% of your students are LGBTQ and you have a bumper sticker that includes a homophobic slur, I think that might be a different case. But again, just a sort of like ordinary political statement in and of itself, no, I don't think so. All right, what about belonging to the North American Man-Boy Love Association? I didn't make these up, by the way. This is totally real. I don't need to explain what that is to you guys. It's kind of self-explanatory. Can a teacher be fired? I mean, you have a right to a free association, right? You can belong to any club you want. Can you be fired as a teacher because you belong to the North American Man-Boy Love Association? So the courts have held yes, you can be. Because, and this is their reasoning, the North American Man-Boy Love Association advocates like illegal activities between, adult men and adolescent boys. And this particular teacher taught middle school. And the school presented significant evidence that essentially a whole bunch of parents refused to allow to have their adolescent children assigned to that teacher's class. And that because of the sort of special caretaking relationship that teachers have of students, that it was legitimate and reasonable for parents to fear and the school to fear that that this person's views might influence their relationships with their students. And because of that, the disruption was too great, and this person's interest in belonging to that association didn't outweigh it, so they could be fired from their job. And in fact, they were. What about publishing a book of relationship advice that contains explicit sexual passages? to be specific, the book is entitled "It's Her Fault," and it includes graphic descriptions of the intimate areas of every woman you've ever been with. Can you be fired for that?
Yes.
Yes. No, this is, again, these are all court cases. This is all true. So there was a teacher who published said book and was fired for it and sued, and the courts held your job as a guidance counselor. He was actually a guidance counselor. Your job as a guidance counselor is to be a safe resource for your students, and maybe your female students might feel a little uncomfortable coming to you with their concerns if they know that your view is all things that happen in relationships are women's fault, and that you hold these sort of very, I would say, retrograde views about women and their space in the world. Yes?
Would it be different if he was talking about sex in like a different way?
That's a great question.
Or like...
So there have been instances where teachers who have performed in sexually explicit movies have been fired because of it, and the courts have upheld that. I think it depends on the age of the kids you're teaching to some degree. It depends on the nature of the speech, right? And it depends on how public you are about it. Right? These are all, the reason that I said this is hard is because these are all very fact-specific situations. So like, there is no rule that says teachers can't talk or write about sex. Also, some people have to teach about sex, right? I get to go give a talk about sexting to high schoolers all the time. It's just, but, you know, it's all fact-dependent, so don't take any of these as like hard and fast rules. This is just illustrative of some of the ways courts have talked about this. What about, oh, did I miss one? Okay, I'm just going to tell you another one. What if you publish a blog anonymously that calls your students lazy, whiny, entitled losers? Can you be fired for that? Yes, yes.
You have to.
She didn't use their names, and it was technically anonymous for her, but like seriously, folks, nothing's anonymous on the internet, so don't even think it. It was but the kids found it, because the kids are going to find everything about you. This is the great thing about teaching high schoolers. They will soon know more about you than your mama does. So that teacher was, in fact, disciplined because and in that case, the court even just gave her the benefit of the doubt and assumed that it was on a matter of public concern to publish that blog. But even giving her the benefit of the doubt, essentially they relied again on the need for a trusting and open relationship between teachers and their students, and how could the students feel comfortable and safe in a class where the teacher had publicly bashed them for being lazy, entitled, whiny losers. And the commentary was pretty biting, right? Like, she described particular kids' appearances and like mocked them. And so, again, the totality of all of those circumstances, the court held that her right to express her views about that didn't outweigh the school's interest in ensuring that their classrooms were safe places for their kids. And then the last one is, what about if you publish music with violent themes? There was actually a situation on this just pretty recently in Washington State. You're an artist. You have a side gig as a death metal band leader. I don't know, what do you call the leader of a death metal band? There's got to be some word. Death metal singer, okay? And you sing about blood and guts and death and goring people with bayonets. Can you be fired for that? So in this particular case, the school decided not to take disciplinary action against the teacher, and I think that was the right call. Because it was very clearly in an artistic context that was wholly separate from their personal views. It's not like a blog where you're saying, this is what I, individual human, feel, right? Like, sometimes people write song lyrics, and they may not feel all the things in those words, right? And because it was sort of wholly separate from their personal, sort of stamp. And because it was artistic expression outside of the school environment, the school concluded that the teacher had a First Amendment right to publish that music. And there was no real evidence of disruption, right? Like, people called and they were like, dude, did you know about this? But it wasn't that the students were like, oh my God, I'm terrified of this person because they sing death metal. It's not like Footloose, right? So again, I think that's the right call, right? As a teacher, you still have the right to a life outside of school. The big question you should always be asking yourself is, will this life I have outside of school result in people in my classroom feeling less safe? Will it result in people in my classroom feeling like I can't do my job anymore? And if either of those things are true, then it might be one of those ones where you pause and think about whether it's necessary. Yeah.
I'm interested to like relate that back to like pornography, because like that is like both an art and a trade. So it's like someone's literally doing their job, you know? And it's an incredibly recognized job, so how could that affect like...
Yeah, I mean, and I will say that I haven't seen court cases discussing the pornography issue. Those are just situations that have been reported in the media and then resolved in other ways. So I don't know how the courts would come down on that. I do think, though, that what would, as evidenced by the obscenity cases, right, in schools, the courts are pretty squeamish about the government being the vehicle by which anything related to sex is injected into the lives of young children, right? I mean, like, we don't even have compulsory sex ed in this state, right? And so I would not be surprised if that squeamishness came to play in a court case. That doesn't mean ultimately that the teacher might not prevail for all of the reasons you said, right? That like this is legal activity for adults to do, especially if you are doing it before you become a teacher or, in your off time, and especially if you are taking, steps to separate that identity from your identity as a teacher. But again, I think there is a counter argument, and it'd be a fact-specific situation. Yeah.
You said the students can go home and call the teacher a bitch, let's say, but can they do it on a blog?
That's a great question. Can a student call you, or I guess the question is really like, if kids publish blogs or social media posts or things that say things that are, that they can't say in school, could they be punished for it? And where the courts have come out on that is basically, if what the student says has a significant disruptive effect on school, then yes. The most common area this comes out is bullying, right? Like cyberbullying or like posting really awful things about one of your peers. In those cases, the courts have pretty uniformly held that, like, yes, you can be disciplined for relentlessly bullying one of your classmates online because that has a direct and negative impact on the school. Whether saying mean things about your teachers rises to that level is the only cases that have gone up to court on that have involved pretty like severe kid stuff, like not just calling your teacher a bitch, but like threatening to kill your teacher or saying like, I'm gonna shoot her because, and then like, drag her body behind a car, I think was what that one case said. The ACLU's position has been that unless there's something else, right, those words outside of school cannot be used to deprive a student of their right to education. But there have been cases where the courts have held that specific, targeted, relentless threats to teachers can be the basis for student discipline. Did that answer your question?
Yes, I was going to put a little different spin on it. But I was curious about the case that happened in France. This is another thing you were talking about with clothing. Mm-hmm. Remember, it's been 15 years. The French teachers and administrators went to the government and said, we don't want overt religious symbols on the clothing of the students in the school. And that means crosses, big crosses, and that means veils. Mm-hmm. And the government enforced it.
You can't, sorry, go ahead.
Because in France, as you know, secularity or laicite is a big value. If it is anything like that,
No, that
present in America?
that would be unconstitutional. So our First Amendment isn't just about freedom of speech. It's also about includes the free exercise of religion. And so governmental banning of students' use of religious symbols in school would be patently unconstitutional. Probably also race discrimination. And so you wouldn't have that kind of situation.
You know, the tough one is the veil.
I don't think it's tough.
We haven't had that problem, but they've been having it in Quebec.
I mean, again, the First Amendment categorically protects the rights of people to wear veils and other types of religious clothing. It's not. I don't think there's a legitimate basis to debate that under the First Amendment in the United States. Again, other countries might have it be different, but that's not the way it is here. Yeah.
If a teacher puts something online, like them doing like a comedy routine or singing or acting in something in school, and a student posts that online, does the school have a right to pursue punishment against that kid under the argument of harassment of the teacher?
I don't know. So harassment is a pretty high bar, right? It's not just you said something that I don't like, right? In order to constitute harassment, something has to be so severe and pervasive that it prevents you from doing your job. And I think this is one of the challenges of the internet age, right? Like, I'm super glad that I made it through college before there was social media. Super awesome. It saved me many a situation that I would have had to explain to the 12-year-olds. But when you put things out there, right, you put them out there. And attempts to sort of compartmentalize that life are, I mean, honestly, it's one of those things where I'm like, resistance is futile, folks. Could a school theoretically discipline a kid for reposting something that you put out in public? If they did, I might have a call with the school. Like from a student advocacy point, unless there's something more than just I shared you in a play that you did that was kind of embarrassing, because like I did some super embarrassing plays. I did, but like without something more, I don't think that would rise to the level of harassment that would justify discipline.
So if that happened and the school removes students from that class because like the teacher felt harassed, that's not okay.
Removing kids from one class to another is different than depriving them of their right to education, and so there are different levels. I mean, I think it sounds like there are a lot of facts in this situation that I would want to know about before I would opine. Question?
I was wondering more so about so let's say you have a math teacher who wants to support his or her students, and let's say that they think it's supportive putting up like a flag that says, a rainbow flag that says, I love all my students, or something, that's like meant to be supportive, but it's a direct opinion that it could be considered.
Yeah.
So I'm wondering, would that be protected?
So if you put things you put on your classroom walls for all students to see are technically within the umbrella of school-sponsored speech, which means that the school could direct you to take that down, and if you refused, they could discipline you for that, right? So this is why I think it's really important to know the culture of the schools you're going into, because if you're in a school that's going to bar you from saying, like putting up a flag that says all are welcome here, that may not be the place for you, right? But if it's on the wall, it's the school's speech. It's not your personal speech, legally. Yeah.
I was wondering, because in these times, like MAGA hats.
Oh, God.
So that
Yeah.
a symbol,
Yeah.
right, and being wielded by the President of the United States and others as explicit.
Yeah. So that, yeah. Yeah, no, I know exactly, and this is a really, really challenging one, right? So let me back this. Let's talk about students first and then teachers. I think under the law as it stands now, a student wearing a MAGA shirt or a Trump shirt would be legally protected, right? Unless, and I'll give you a very specific example of this, the student was in some way deliberately wielding that expression to harass or intimidate other students or teachers. So there's one situation that I was made aware of where 4 children wearing MAGA shirts surrounded the only Latino student in their school and chanted around that kid, "Build the wall, you're going home." I think that is very different than the simple passive wearing of a MAGA shirt. So again, shirts are just shirts, words are just words, and in and of themselves, I do not think that a student can be disrupted for wearing those words. Now, if a student takes action to target another, that is different. And the other thing I will say is that schools, one of the tensions I find in all of this is that schools will often say, well, this is protected speech, so I can't do anything about it, right? It's protected for kids to wear the Confederate flag, so I can't do anything about it. It's like, you know, there is a space between doing nothing and expelling children, right? And it's education. So schools have every right to take principled stances in favor of inclusivity, in favor of non-discrimination, against bullying, harassment, and targeting. And in fact, it's in Washington legally required for them to have affirmative stances against bullying, harassment, and intimidation, and to take proactive steps to prevent those things. It's public. I mean, it's the Washington Law Against Discrimination, right? And so, if you have a school where, and I have in fact worked with families in in some of these schools, right, where LGBTQ students are being relentlessly harassed and targeted, you may not be able to ban the kids wearing the Trump shirts, but you absolutely can have a school-based assembly about, like, what is gender identity, what does it mean to be LGBTQ, and what are our expectations of how we treat each other in this inclusive school environment, right? So, you know, again, just because something isn't unprotected under the First Amendment doesn't mean that schools have to take this like laissez-faire, like, oh, well, we can have no opinions or viewpoints about this. Schools can have opinions and viewpoints. They cannot discriminate against their students based on the students' viewpoints and opinions, but they can have opinions. Question in the back?
I have kind of like a little scenario.
Yeah.
I think so. Earlier, like this month, there was like the Teacher of the Year award, and she was wearing buttons.
Yeah.
Well, I went to that high school that she like worked at.
She's pretty awesome.
Yeah, she's super cool. But she was wearing buttons in in like a silent protest about like had like LGBTQ and then other stuff.
Yep.
It is like obviously like my school would have supported her because of what she's done in the community. But with other like schools or other like instances, like how would that trying to think like how would that work if she were to kind of be disciplined in a way for her silent protest?
Yeah,
With,
I mean,
like the president, if that makes sense.
yeah, so, you know, so silently wearing, so Mandy Manning wore to her meeting with the president LGBTQ inclusive and immigrant solidarity buttons on her lapel, and, you know, gave a speech talking about she teaches refugee and immigrant students, talking about the importance of America being inclusive and welcoming to those students. If hypothetically she were from a district that then decided to discipline her for wearing, you know, a rainbow flag pin, I think she would have a very good claim that that was a violation of the First Amendment. Because again, how is that disruptive to the school environment, right? Like, it'd be hard to imagine how you could make a claim that like wearing a button to a meeting 7,000 miles away disrupts the school environment or is disruptive of the school environment. Because again, the fact that other people might not like it in and of itself is not disruptive, right? And I think that's where some of the school cases get challenging, right? Because they talk about like the special relationships between teachers and students and parents. But again, it's not enough to have them like not like it, right? Or disagree with it. There has to be something more, essentially a reasonable and pervasive feeling among the teachers and parents that like this person can't do their job because of what they're saying. And wearing a rainbow flag pin doesn't give really any indication that a person can't do their job. Yeah.
So what if like a teacher took like a very hard stance on like a student wearing something, but it was like they wore a Confederate flag, and then the next day the teacher had like a presentation about like the implications of like associating with Confederate flags, stuff like that. But the parents have a right to like, I guess like, cause like you would be making claims about like racism and like murder and things like that if you wanted to like go in depth.
Yeah.
So like that would be kind of like an association.
Mm-hmm.
So like would
Yeah.
parents have a right to sue?
So parents have no right to control the individual lessons of public schools. And there are parents who strongly disagree with this, but like legally, they have no right to dictate to the school what the curriculum is, right? Curriculum is set by the school board, and if parents don't like what's going on, they can go to the school board and say, we want there to be no lessons on this thing, right? I do think, though, that teachers need to be, I say that like there should be educational opportunities here. I think that there is one of the most challenging things about being an educator, especially an educator who has strong opinions and a social conscience, is ensuring that you are giving students, that you are leading your horses to water, right, rather than making them drink. So making sure that your lessons are structured in such a way that you are giving students full and fair information, that you are allowing students to process that information and take from it what they will, that you're not penalizing students because they happen to come to a viewpoint that is different than yours. But again, I don't think that a parent would have a right to sue you or sue the school for any kind of discrimination because you taught a lesson about the Confederacy. Like, people teach lessons about the Confederacy all the time. And particularly if you do it well, as I know all of you will, right? Pull some primary source materials. Let the kids talk, right? And then it is not, again, the school penalizing students because they hold different viewpoints. It is the school providing opportunities for students to engage with material and formulate their own. Question over there? Yeah. Oh, and then I saw.
The religious freedom.
Mm-hmm.
The movement for the religious freedom laws that are popping up, especially in conservative states.
Mm-hmm.
More conservative states. What's the implications for teachers who identify as LGBTQ, higher ed, including higher ed, K-12, and this idea that students can begin to opt out? I know that these are starting to pop out, that they can opt out of courses with LGBTQ educators running them, for instance, as bakeries.
Yeah. So in Washington State, we do not have that problem. We have a law against discrimination that prohibits discrimination in public employment on the basis of, among many other categories, gender identity, sexual orientation, or sexual expression. The courts have been holding that it is illegal to discriminate in the terms and conditions of employment, that Title VII's prohibition on gender discrimination also encompasses discrimination on the basis of sexual orientation. I do think that it is likely that those prohibitions will, like, there will eventually be a clash between those kinds of like opt out because there's a gay teacher and Title VII, because of course it's a term and condition of your employment whether students are assigned to your class or not assigned to your class, right? I do not think that the Masterpiece Cake Shop case really weighs in on that at all. And of course that decision hasn't come out yet, right? But the argument in that case really is not necessarily about religious freedom so much as it's kind of a First Amendment argument. It's saying that like my cake is speech and I have a right to speak or not speak based upon my religious views. So I do think that is different, right? That because typically what the courts have held is that you either get to opt in or opt out of the public education system, right? You don't get to do like sort of half in, half out, right? I'm in, but only if I get to dictate this thing. And I would imagine that principle would apply in this situation as well. You had a question over here, and then I think we're past time. We past time? Okay.
I think I answered it.
Okay. So next slide. Do I have another slide? Oh, social media. So, that was where the rude, lazy, disengaged whiners are. So these are just more teachers behaving badly on social media situations. So I'll run through these really quickly again as examples. Posting a picture of yourself drinking. That teacher actually was fired. It didn't go to court, but it did go to court, and the court did actually uphold her firing. I know, that case I think was wrongly decided. Like, it was like, well, she posted essentially like, it was a lot of drinking, sort of like every weekend with like different captions. It was like drunken pirate, and she taught elementary school. And so the court did, in fact, uphold her discipline. Communicating with your students as friends on Facebook is a no. Do not friend your students. They are not your friends. And particularly if you are having very personal conversations with your student friends on Facebook, just don't do it. That teacher was also disciplined, and that discipline was upheld. I told you about the rude, disengaged, lazy whiners already. A school security officer who posted on social media about black thugs. That security officer was fired, and the court upheld his discipline because his role as a security officer was to mediate disputes, and hard to mediate disputes when you are sort of racist. Also the court did cite to the disproportionate rates of arrests of students of color as another reason for not expressing racially charged views is an important value in that particular job. Bashing your colleagues on social media. So if you want to talk about how all the other teachers are awful, that has also been upheld as a basis for teacher discipline. And then the most recent one, hosting under a pseudonym a white supremacist podcast. That has not gone to the courts yet, but some factors that I think are going to be important in that case is that the teacher, in addition to hosting the white supremacist podcast, also went on other white supremacist podcasts to talk about how as a teacher she got to sneak white supremacy into the schools. I think that factor alone is going to be pretty important in the way that case ultimately develops. Yeah.
I just had a quick question about social media. Like, for example, I have a colleague who, he has an Instagram account, but it's separate from his personal. And it's just one that his students can follow.
Mm-hmm.
He's a science, so he does cool science stuff on
Yep.
there, but also just personal pictures of him and his wife, and it's harmless, but it's separate. But I wonder how does that work?
I think the question really is, does your school have a social media policy? So schools are kind of slow to the bandwagon on social media policies, but there are a number of districts that have adopted policies that essentially say, you do not get to communicate with students and parents over social media unless it's on a school-sanctioned account that we know about and can monitor. If your school doesn't have that, right, I think what that teacher is doing is absolute best practice, which is keep your personal account and your school account separate. And make sure that you put or say nothing on your school account that you would not put or say in your classroom. Think of that social media account as an extension of your classroom. And, again, teachers have rights to speak as private citizens, but the case law on this has been relatively deferential to the school's interest in preventing disruption. Now, do I often think that the school is that the courts are going overboard in that? Yes, like the drunken pirate case is one that I think was wrongly decided, right? But those risks exist. And so if folks are going to be mixing those things up, you should do it with the awareness of what the potential consequences might be. Next slide. So that's all I had. I have time and space for questions, maybe on this or other topics if folks would like. Yes.
I have a religion question.
Mm-hmm.
So, are there any limits of a teacher, let's say in December, dressing Christmas every day on their body? I'm not talking about posting things on bulletin boards, which wouldn't be allowed, but in Washington State. But especially if they're Jewish or Muslim or atheist kids in the class who would should there be any limit?
I haven't seen any court cases on that. And so, I'd just be speculating. I mean, again, a teacher's clothing, right, can't be limited by a school as a general matter if it is expressive clothing, right? Unless there is some kind of like disruption to the school and again, it's the fact that someone may not engage in Christmas in and of itself doesn't seem to be a basis for a disruption. There may be more there, right? Like if this teacher is constantly proselytizing religiously or playing religious Christmas carols in their classroom, I think that would be a different question. But the like Santa hats all the time, I don't think, to me that doesn't seem to cross the line. Question here.
So we actually had this one thing happen in my high school last year where there was a fight in the lunchroom where a boy pushed the girl like across the lunchroom, and someone else got a video of it and it went viral, and it was a huge thing. Like I remember it got lots of retweets, and I was just wondering, how would you do it? Just because I want to compare how my school handled it versus how you would.
I mean, publishing a video of broadly publishing a video of a school altercation is likely intended to harm one of the people involved in that altercation, probably the person who got pushed across the room and fell down, right? If that is the intent with which it was done, I think you could potentially discipline the student who engaged in that behavior. I am just, and to lay my cards on the table, I think suspending kids is just a terrible approach to everything. I don't think it solves problems. I think it is much more likely to exacerbate them. And so, I say this from that mindset, and folks might disagree, but I don't think suspension would be a great response to that, and I instead would advocate that the school do some conversations on responsible social media use and teach kids about the implications of retweeting viral videos and share statistics about cyberbullying, and try to have a more sort of restorative educational approach than oh my God, you took this and now everyone who retweeted that video, now you're all in detention, because I just don't think that helps. What did your school do?
So they did the opposite, and they did suspend. The people that were in the fight got in less trouble than the person that recorded it. So the person that recorded it was a senior, and it was getting close to graduation time, so the school decided to suspend her up until graduation. And they were trying not to let her graduate, but
yeah,
they were like, no, we gotta graduate.
Again, I'm not sure that solved any problems. So, yeah.
Oh, and they deleted the video.
Well, then that makes good sense.
There were memes.
Yeah.
Yeah.
Again, social media makes me sad. Yes.
You never used the term role model, I don't think, in your whole presentation, but a lot of the things you're saying are really saying the teacher's a role model.
Yeah, and I didn't use that in part because it seems pretty fuzzy to me, but you're right, that a lot of the basis of those teacher speech cases are that teachers aren't like, the secretary in a state legislator's office, right? That teachers really do have a sort of public face, and when I said the kids will find out everything about you, I was not joking about that. And that, I think, in a lot of these teacher speech cases means that teachers often come out with less protections than other government employees do because of the particularly valuable and amazing role that all of you will play in the lives of molding your future students' brains. And so, I think that runs through it.
I think we gotta face that, given what you've said, as the way so many of these cases have come out. If you're going out to be a teacher, you have to accept that there's going to be some of that.
Yeah. I don't think, though, that should come at the expense of, being a responsible citizen having political views, right? And again, I think that the question that I pull from a lot of these cases is not just like, will all the kids want to do the thing you're doing, right? Because certainly not all of the students that I taught wanted to go, like, you know, on protest marches all the time. Some of them did. I really loved the kids who wanted to go on protest marches. But, you know, like, they weren't all, that wasn't in all of their bones, right? But the question that I think is important to ask is, like, is the fact that I'm doing this going to make any of them feel unsafe or unwelcome or unable to come to my class and feel like they can learn from me, right? And if the answer to those questions is yes, that should be the kind of thing that gives you pause. It's not that you can have no political views. It's not that you can have no private life. It's, does your engagement in that, will that, if it comes into your classroom, make your classroom an ineffective place? Yeah.
Just students and kids, right?
Yeah.
Does that include higher ed and students above the age of 18?
The standards are different in higher ed because you are adults, and the sort of paternalism in the sort of K-12 cases, which really is all about, like, protecting the innocent minds of the people who we compel to be here by penalty of law, right? In the higher ed context, you are all here because you want to be, and presumably worked very hard to be here, and you are all adults. And so that kind of, like, paternalist, like, let's shield you from government overreach is much less of a force in the higher ed context than it is in the K-12 one. Any other questions? Well, thank you all for coming out and geeking out on the First Amendment with me, and good luck.